I certainly encourage you to do that. Good evening, this is John Milburn for LAWS11057 Introduction to Law. This is week 10, and this week we're dealing with a number of issues. Last week I invited you to speak or to do some preliminary study in relation to ethical duties. So please keep anything to do with ethics foremost in your mind. When you're answering a question in relation to legal research, legal problem solving generally, it's always useful and quite often necessary to think about the legal ethical issues that arise. It may be that the particular question doesn't actually call you to refer to a legal ethical rule, but if it does and you add it in, even if it's not asked for, it will be most welcome from your assessor. So ethical issues are always very important. So if you haven't already done some research, I do need you to look at the Barrister's Rule and the Australian Solicitors Conduct Rules. And I invite you to look at the excellent website from the Queensland Law Society, which deals specifically with ethics. So before we get to that, there's a few other issues that I want to talk about. One is collaboration, and contrast that to collusion. I trust that you have now some clear ideas as to what you can do, what you can't do. If not, please consider that. Have a look for the Queensland Central Queensland University policy in relation to collaboration. And it's important that you understand what we mean by plagiarism, plagiarism procedures, student misconduct, plagiarism policy, and you'll find those on the UNID website, and there's some introductory comments on the Moodle landing page. Lawyers always, in practice, must always consider their ethical obligations, and one of the important practical aspects that lawyers find themselves dealing with relates to the issue of undertakings. Now, does anyone know what I mean by an undertaking given by a lawyer? Can anyone give me an example of typically where a lawyer may provide an undertaking? So this is kind of ethical issues, so I'm just working towards some things here. Undertakings. So a very serious promise, a neighbourhood dispute is Tim's example. Tanya says, undertaking to hold documents at another firm's direction. Peter says an undertaking to provide evidence, etc. Very good. Now, typically undertaking is to bail. Typically, undertakings are given to one of two parties, generally speaking. Must be within the firm's control, Tanya says, yes. So, as a practitioner in law, can you imagine who would be the recipient, generally, of an undertaking that is provided by a lawyer? And I'm thinking of two particular categories of recipients here. Any takers? The court, the client, defendant, client. All right. The two that I had in mind were court and colleagues. So you don't often give undertakings to your own client. I suppose you could, but any undertaking given by a lawyer is very important, and it is, as I think Tim mentioned, very serious issue. If you give an undertaking to a court or a colleague, you must be in a position to follow through and make sure you complete that task. If you don't, then it will have serious consequences. So have a look at the Australian Solicitors Conduct Rules, the Barrister's Rule, to get an idea of the consequences for failing to follow through with an undertaking. For example, Rule 6 of the Australian Solicitors Conduct Rule provides that a solicitor who's given an undertaking in the course of legal practice must honour that undertaking, ensure the timely and effective performance of the undertaking, unless released by the recipient or by a court of competent jurisdiction. That's how serious it is. And when the solicitor provides the undertaking personally, then it's no excuse to say, well, I gave the undertaking on the promise that my client would do something. My client's let me down, therefore I can't follow through. that won't wash. Once you give the undertaking personally, you're committed. It doesn't matter if the client doesn't follow through. So from a practical perspective, what you need to consider is an alternative to wording the undertaking very clearly is, I undertake to do this. The alternative is, on behalf of my client undertakes to do this. Do you see the difference? So on the one hand, it's a commitment that you're making for your client. The other is an undertaking, a commitment that you make personally. So please be aware of that and think about how it might be useful in practice. In a court context, it may be an undertaking to file documents or an undertaking to do something else. To a colleague, it might be, as I think Tanya did point out, an undertaking to hold documents at another firm's direction. So we see that commonly in conveyancing matters. Any questions then about undertakings, what they mean, how they're given, who might be the recipient, where you might look to determine the issues of how they may be breached and the punishment for breach of the undertaking. No questions? All right, let's press on then. Question, can disputing parties make an undertaking? Yes, they can. So they may be in a position to make undertakings to each other, and indeed quite often undertakings are provided by parties to a court. And as a lawyer, you might be involved in that process. And Lachlan says in criminal law that might happen. So Lachlan said undertakings to bail, lawyer doesn't generally give it to the client, but they will explain to them from what I've seen. Yes, so there might be, for example, an undertaking to explain something to a client that a lawyer gives to a court. So, for example, an end-up committal.
Yes, I was just going to say, isn't undertaking to bail, that's like when they have to return to the court, isn't it?
It is, yes. So that's a client commitment rather than a lawyer's commitment. But there's a process in criminal law called a committal, and it may be what we call a hand-up committal, which is where the lawyer effectively stands before a magistrate and says, in relation to this indictable offence, I have instructions from my client that my client consents or accepts that there is a prima facie case against him or her, and consents to being committed to the district court or the Supreme Court, as the case may be. At that stage, it would be not uncommon, in fact quite common, for the lawyer to say, I undertake to explain the nature of the committal or to provide certain documentation to the client at a future time, things of that nature. All right. Now let's digress for a moment and talk about critical thinking. Critical skills, critical thinking skills are very important, and you need to develop your skills to become a critical thinker. To provide some context and detail, have a look at your textbook and consider page 304, which deals with the general issue of critical thinking. From there, flick forward a little to page 310, and in particular, table 8.2. You'll see in that table that there is a brief reference to various critical skills: interpretation, analysis, evaluation, inference, explanation, and self-regulation. These are 6 key critical skills. Now, given that these are critical thinking skills, you might expect that during the course of your legal studies, examiners will test you in relation to one or more of these 6 critical skills. And you'll know what type of critical skill the examiner seeks to examine you upon, based typically on the first word of a question. So if, for example, the question that you have in the take-home paper asks you to interpret something, then you must look at the critical skill, understand what we mean by interpretation, and answer the question accordingly. Alternatively, it may be that your examiner asks you to analyse something. Again, understand what the term means and tailor your response to suit the term. In other words, if the examiner is asking you for an analysis, then you won't expect to get as good a mark if what you in fact have provided is an explanation. I hope that makes sense. These things can be linked quite closely, but you need to be careful, and I would make this part of your, if you like, level 4 toolkit into the future, and have something ready to go so that before you even attempt to answer a question, you have a clear idea of what it is that the examiner wants you to do. In other words, you cannot properly answer the question unless you understand what is meant by the critical or relevant critical skill. Now, does that all make sense? All good? All right. So interpretation is the ability to identify, if you like, the surface meaning. It's the ability to understand. Analysis largely requires you to consider and identify hidden features. So it's critical in that sense. Evaluation is an ability to assess something, to determine whether it's good, bad, etc. And you can see there are obvious crossovers here. Inference is the ability to draw conclusions. Explanation, the ability to communicate results. And self-regulation, which is a little different because you won't see that typically in an exam question, is your ability to apply other skills to your own thinking. So what I'm going to invite you to do is to have your own little catchphrase that makes sense to you in relation to these sorts of words, something that you can refer to probably first thing you do before you answer any legal question in this unit or other units. You can add to this. So the table 8.2 is not exhaustive. There might be other words, other skills that you need to consider. All good? Okay. Now, it is a bit Iraqish. Reading the law. If you haven't already looked at the excellent video by Scott Beattie, Associate Professor Scott Beattie of this law school, please consider it. It's on Moodle, and it will give you a good idea of how to read the law for students. A little bit of everything this evening. The next topic is judicial activism. Can anyone tell me what we mean by judicial activism? What does that mean? You can unmute or you can use the chat facility. Judicial activism. You can give me an example if you like. Social advocacy, says Tim, question mark. Any other takers? Now,
could
yes,
we have a bit of context to it?
Yeah, I'll give you that now. So when we talk about where the law is created, we usually think Parliament, don't we? Or alternatively, we might think of the common law, which is where judges have made law that interprets, if you like, the legislation and amplifies that which is in the legislation. Now, judicial activism is the decision-making of a judge, hence judicial, but in a very proactive manner. Typically, when I think of judicial activism, I'm thinking of the High Court. And it's where a judge, or more likely several judges in the High Court, deal with an issue which has the effect of reforming the law in a somewhat parliamentary type way. So the reformation of the law is so profound that it is, if you like, creating something that just didn't exist. And judges in the High Court typically will use this if the law is deemed to be unjust, obsolete, or defective. Now,
I
yes,
was just
Lachlan?
going to ask, how often does that happen?
In its real true sense, not very often, because whilst judges do through precedent make laws effectively, they're really refining that which is already there. They're not really taking the law and reforming it completely. The example I always have is Mabo. So the Mabo decision, in that case, without Parliament creating any laws to this effect, the High Court recognised the existence of native title. Very profound reformation of the law. Parliament chose to accept that logic, and the year after the Mabo decision was handed down, created the Native Title Act, which effectively not only confirmed that which the High Court had created through judicial activism, but expanded upon it and set out through regulations and some meat in terms of its activities.
That being said, I sort of have to ask the question again that I have asked before. I'm not sure if I've asked it in this sense, but how often in that instance is there like due compensation considered?
Yes, well, that's sorry, that's a very broad question. I'm not sure I can answer that, Lachlan.
Yeah, no, I just meant like in cases where they've had to repeal something that's affected so many lives. For example, I was reading up on a case today. It's completely irrelevant in the sense that this guy, he got out of, he appealed to the High Court so many times and he's just got his conviction for murder quashed. I just mean like on a scale of something like that, say there was something that was affecting people that significantly, and you know it had put a bunch of people in jail, something like how they're legalizing marijuana at the moment. In terms of that sort of thing, if they overturn something like that, how often will they then go back and look at the previous cases and then issue compensation based on that?
No, that's a good question. I like your lateral thinking. In that particular scenario, I suspect that the answer would be no chance at all. But in terms of people that have been unfairly or improperly jailed, yes, the appropriate procedure would generally be to ask the government to provide you with an ex gratia payment, which is effectively a payment at the discretion of the government in that regard. And where we do have examples of judicial activism, they might well have, for example, in the Mabo native title situation, be followed by reformation through Parliament, and that would usually be accompanied by forms of regulation. And in the statutory provisions that follow, there may be, and often would be, provision for compensation to be paid. So I hope that answers your question, Lachlan. Thank you.
It's just been on my mind because that guy this morning got let off after 19 years of being in jail, and it was like, what do they do in terms of the compensation? But that's another question for another time. Sorry.
No. But also, it is possible to make an application for compensation for wrongful detention.
Really interesting.
So, yes, so that's another avenue, in addition to the ex gratia application that I mentioned.
Okay, cool. Sorry, I was just wondering which subject of law, probably criminal, I'd imagine, does cover all of that sort of thing.
Probably torts, actually. Torts.
Okay, thanks for that, John.
No, that's all right. So another legal principle that you may have come across when you were preparing your toolkit was the rule of law. And the rule of law is essentially part of our legal theory. It underpins all of our legal professional ethics. It provides for professional accountability or political accountability. And it underpins prohibitions against, for example, arbitrary detention, to follow on from a discussion that we've already had. and protects things like the trial by jury. So the rule of law is this a very general thing. We don't have a Bill of Rights in Australia, but the rule of law, whilst not documented clearly, is so ingrained in our common law that there must be a very clear statement by Parliament if there is an intention to overrule something which forms our general body of the rule of law.
That sort of reminds me of how we technically in Australia don't have the right to free speech, but we've got a lot of things that are similar.
Yeah, that's right. We don't have, for example, privacy legislation either, per se. We do have the Privacy Act, but it's more administrative rather than substantive. All right, so what we've been discussing are general principles. You may have come across these as part of your toolkit, but I do want you to have a look at those and think about those in the context of, for example, being committed to justice and having access to justice. And when we talk about access to justice, we can really talk about a wide range of legal areas that come to mind. So criminal law, immigration law, human rights, mental health, guardianship, administration, child protection. All of these things deal with being committed to justice and having access to justice. Because it's one thing to create these laws, but it's potentially an entirely different thing to be in a position to act upon those laws and obtain an outcome that suits. And looking at that brief list of things that I mentioned earlier about different areas of practice, it brings to mind the fact that we have many different courts and tribunals that to some degree provide specialisation in relation to these issues. Another one, for example, is environmental law. So clearly people have a right to access justice in relation to environmental law issues, and there's a particular planning and environment court in Queensland. So for mental health issues, we have the Mental Health Court and the Mental Health Review Tribunal. Some of them cross over boundaries. So family law is primarily dealt with in the Commonwealth courts, but there is some crossover in other jurisdictions. Domestic violence law, for example, is somehow dealt with in the family law context, but it's also dealt with in the criminal law context. So when we talk about being committed to justice, we need to think about these various areas of practice. But when you do, think about them within the context of legal ethical obligations. So whenever you're dealing with issues to do with justice, think about the ethics associated with it. And also, and this is underrated, but it's very important in practice, think about the jurisdiction where matters might be considered and determined, because that's critically important. For example, does anyone know what I mean by guardianship and administration? Can anyone tell me what that means, what that phrase means? Guardianship and administration. Care of minors. Close. If you're deemed incapable of taking care of your own affairs, says Megan. Yes, very good. Power of attorney. So guardianship and administration are examples of substitute decision-making in relation to adults with impaired decision-making capacity. People who do have capacity may make a power of attorney, and they may make it effective and provide power, lawful authority for someone to make decisions should they lose capacity themselves at a future time. But if they do not have the power of attorney, then before others can start to be that substitute decision maker, they need to be appointed. And the appropriate application would be to be appointed as that person's guardian or that person's administrator, or perhaps both. Administration deals with money and property. Guardianship deals with things that are not related to money and property. And can anyone tell me which court or tribunal typically makes the vast bulk of the appointments of guardians and administrators? Can
Is
you
that
take
like QCAT?
it? Is like exactly like QCAT. Yes, it is QCAT. So QCAT shares that jurisdiction with the Supreme Court. So you can't go to the District Court or the Magistrates Court or the Federal Court or the Family Court. You'd need to go basically to QCAT.
Yeah, I learned about that when I was looking after, when I was doing youth work.
Yes. Okay. Yes. And so up until the age of 18, Timothy said, for minors, yes, that would be care and protection or child protection law, which is typically done through the Magistrates Court and QCAT. Once they click over to be adults, it's QCAT and the Supreme Court. So what I'm getting at here is when we think about access to justice, when we think about being committed to justice, you need to consider these different areas of practice where there is clear need for someone to advocate and to advocate strongly, but you need to think about the ethical issues and you need to think about the practicalities. Which court, which tribunal, okay? Likewise, immigration law, very specialised, dealt within specialised jurisdictions. And when you're talking about having access to justice, you need to then think about the issue of procedural justice. In other words, once you've found yourself advocating for someone in relation to issues to do with justice, you've found yourself in the right court or the right tribunal, what is the rule of law that is fundamental to the process? Is that too obscure? So I'm mixing a couple of things we've discussed. So rule of law is, if you like, an overriding principle of our law, even though it may not be written down. If you find yourself in a court, what do you expect in terms of procedural justice? Well, in short, you'd expect a fair hearing.
I was going to say, just for a joke, I was going to say the Vienna Convention.
Vienna Convention, yes. Benjamin said fairness. Just came in at the same time that I said it. So well done, Benjamin. So a fair hearing. Now, what are some of the tenets of a fair hearing? If in a criminal trial, what's some of the basic principles that relate to procedural justice that constitutes a fair hearing? Evidence, yes, it's got to work on the evidence presented at the trial. So you'll hear a judge address a jury and say that the jury must act upon the evidence in the trial and not on that which is information gleaned from outside. So it's got to be evidence, and it's got to be admissible evidence. And I do take quite often evidence and proof, a third-year subject, where we deal with that in depth. Gareth says to be represented by legal counsel. That's a really interesting one. I'll come back to that. Megan says presumed innocent before being found guilty. Yes, absolutely. Lachlan says media coverage. I have to come back to that one, Lachlan. Benjamin says no discrimination. Yes, it's got to be fair, impartial. Tim says expert witnesses, sub-matters, experts as well. So let's look at a couple of those things. Gareth said to be represented by legal counsel. Now, that's a tricky one because the High Court has said that not everyone has the right to be represented by legal counsel in all circumstances. And to some degree, that's a policy decision based on the fact that there just simply wouldn't be enough money to go around. So you will find that people do have to represent themselves, probably regrettably far more often than we'd like, due to monetary constraints. Lachlan says media coverage. So in this sense, yes, our courts are open to the media, they're open to the public, but there are certain circumstances where the courts are closed, which means that the media can't come in, or media can't report on them. So media coverage, as in when a judge may prevent things from being disclosed so as not to influence judicial fairness. Yes, very good, Lachlan. So the judge has that right. And in some instances, Parliament has made it such that procedures are closed to the public. For example, a mental health review tribunal, mental health court, is
generally
speaking, closed.
It was the case that I'm referring to in terms of that is the same one, the 19 years murder trial. It's David Eastman, if anyone's curious.
Eastman, right. Thank you, Lachlan. All right, another thing about procedural fairness is this principle. It's the ability that you have to test your opponent's evidence. In other words, it's not just fair enough for someone to come along and say, here's what I saw, here's what I did, and then walk away. You know, you could be left standing with your hand in the air saying, look, I've got to ask some questions about that before you accept that evidence, Your Honour. Please let me test it. Let me test the quality of that evidence. How do you test the quality of the evidence given by the opponent in a practical, procedural sense? Cross-examination. Thank you, Tanya. Exactly. And of course, there are some rules that relate to that. So, for example, if you're going second, you're responding, then if you're going to ask questions by way of cross-examination, a rule of procedural fairness is that you put things that you're going to put into evidence to the first witness to give them a chance to comment upon it. I'll give you an example, and this is the rule in Brown and Dunn. It's Brown v. Dunn. We call it the rule in Brown and Dunn. It's an 1894 case. Don't worry about the case, but the principle is important. And basically it comes down to this. Before the second party can ask the court to reject the evidence of a witness called by the first party's witness must be at least given a fair opportunity to reject or comment upon that which the second party is going to allege. Have I confused you? Smith against, yes, Lachlan? No.
Oh, I was just going to say, yeah, a little bit.
Okay. So Smith against Advanced Electrics, PDY Ltd, 2005, 1 QDR 65. And the Queensland Court of Appeal said, look, the rule in Brown and Dunn had been breached because there was a failure to cross-examine a psychiatrist. What happened is that there were two experts, and the first expert gave evidence, and the second party brought an expert evidence that gave evidence, but they didn't ask the first witness to comment upon those things which the second witness was giving evidence about. So therefore, before you could say, well, that first party didn't know what they were talking about, you've got to say, look, I'm going to suggest to you this and this, invite your comment. Does that make sense? So these are rules of procedural fairness. Now, another important rule of procedural fairness is the ability to refuse to answer a question that might incriminate. So if you watch American shows, what do they say? That we plead the Fifth Amendment. Is that what the Fifth? Tim's onto it. We don't have the Fifth Amendment in Australia, but we have the principle. So you're perfectly entitled to generally to say, I'm not willing to answer that question on the basis
Can you
it
say
might
that
incriminate
in
me.
court?
Yeah, you can. Yeah, you do. And in fact, the person asking the question should not ask it unless they've got essential permission to do so. Now, we do
Even
have...
if they have, sorry, John, if they have permission to ask it, can you still say that as a response? And how many times can you use that before you become, in contempt, so to speak?
That's a very specific question. Perhaps if I could just explain the general principle, and that might assist you in understanding it. So I'm not exactly sure what you mean by who would be asking. So you can't badger a witness. So that's a whole kind of different area. Now, what was I was saying? Yeah, we don't have the Fifth Amendment in Australia. We don't have anything per se in Australia that says that. So it's kind of one of our rules of law, but Parliament can overrule it. So there are two exceptions to the general rule. about your ability to refuse to answer a question on the basis that it might incriminate. The first is that Parliament have made it clear that certain bodies have the ability to summons people and, usually in a closed context, ask questions where they must answer. So I'm thinking of ASIO, the Australian Crime Commission, the Crime and Corruption Commission. So in those jurisdictions, in certain circumstances, you are obliged to answer a question, even though it might incriminate you. Royal Commission, Senate inquiries, yes. So these are different forums where that general rule may not apply. And the second is this: if you're charged with an offence of, say, stealing, and you go in to give evidence, and you don't have to. If you're a defendant, you don't have to give evidence. But if you choose to go give evidence, then if the prosecutor asks you directly, did you steal this item, then you have to answer the question. You can't refuse to answer in that circumstance. Now, I think, Lachlan, your question was more in terms of, look, if you continue to ask this question, are you going to be in contempt of the court? Is that what you're getting at?
Before so you said that they could answer something by saying, no, I don't want to, I'm not going to answer that because I'll incriminate myself. But if they, in the example you just used with the stealing, they had to answer the question. I'm just a bit confused by that.
Sure. So the general rule is there, but there are two exceptions. And the first exception is where Parliament says, in this particular jurisdiction, in these particular circumstances, then you have to answer the question. And the second scenario is, in criminal law proceedings, a defendant does not have to give evidence. So they're perfectly entitled to refuse to go into the witness box. But if they do, the Our Evidence Act in Queensland says, then they've got to answer questions about that case. So if they're charged with stealing a push bike at a certain place at a certain time, in that circumstance, the defendant, the prosecutor can ask, did you steal the push bike at this place at that time? But the prosecutor can't take the opportunity to say, oh, while you're there, I'm going to ask you about this robbery that occurred 3 months ago. It's not part of the charges. There's no obligation for that question to be answered. Only the one in relation to which you're charged. I hope that answers your question, Lachlan.
Yeah, that makes sense. So they can only plead the fifth, so to speak, if it's in relation to something that's different.
Yes, that's it. Yep.
Okay, that makes perfect sense.
Great.
Thanks, John.
Thank you. All right, so think about issues then to do with restorative justice and retributive justice. So when we talk about restorative justice, and I do this in ADR, it's another unit that I take quite regularly, we deal with the thing called justice mediation, which is where victims, offenders come together in a mediation type situation in criminal law matters. And the basic idea is that the parties themselves sort through issues, and it's an opportunity for the victim to get some closure, to better understand, to feel safer, to have a say in the process, and from the perpetrator's perspective, to better understand the actual impact of the crime on the person who's sitting opposite them. So in certain circumstances, restorative justice, justice mediation in criminal law matters, is a great way to deal with issues of access to justice for both the defendant and for the victim. So what we're talking about tonight, general principles of getting you thinking about the way in which our law has this overriding principles that aren't really written down, but are fundamentally important, and the ways that they can be used in practice in a practical sense, and how sometimes there might be exceptions to these. When you're thinking about access to justice, one of the key issues generally is lack of money. And we talked about, Gareth asked the question about representation by legal counsel. So unfortunately, generally speaking, if you can't afford a lawyer and you're not available, you're not able to obtain legal aid funding. than you are on your own. Now, the courts, the Parliament have created some situations to try and level the playing field by having lawyer-free jurisdictions, for example, in the minor civil dispute jurisdiction of QCAT. But that's only one part of QCAT. That's only up to the 25,000 for certain types of disputes. But lawyers regularly appear in other areas of QCAT, for example. So when lawyer-free jurisdictions is relatively limited, and even then, you can normally apply and obtain the approval to have a lawyer represent you. Now, I know that I'm moving fairly quickly through these issues, but okay, so Peter says, in fair work, you need to explain why a lawyer is needed. Yes, and that's generally the rule. If it's a lawyer-free jurisdiction, so to speak, there's always the ability to have someone come in, but you may need to explain it. Complexity, individual circumstances, consent from the other side. These are some of the issues that you might consider. Like union reps. Now, when we talk about justice and obtaining a fair outcome, traditionally lawyers have thought about court process and litigation. But over the last 20 or 30 years, we have had a great change of emphasis in the way in which we practice law as practitioners. I hope you don't mind me using this term, but I'm going to use the term holistic advice. So what we're really saying is that what we're talking about is thinking about different alternatives to litigation. So when I went through law school in the 70s, it was really all about someone's done you wrong, therefore you sue. And this is how you sue, and this is what you argue in court. And that was pretty much it. That was the whole emphasis. But now it's much more holistic. What that means is that when you're faced with a client at first instance, you need to undertake some form of legal triage, for want of a better term. You need to think about different options that might be available. I've mentioned tonight mediation, for example, which is one that people typically think about when considering options to litigation. And really it comes down to this, that what you're looking to do is provide advice that will best assist your client to obtain justice with working within the ethical guidelines and making sure that there is a fair outcome. Now, sometimes you've got to take into account that your clients may not be thinking entirely well at the time they come to see you. That might sound a bit rash, but I think part of your role when you're initially taking input from a client is to think, are they acting upon emotion or logic, or are they trying to simply pursue a principle at costs which far outweigh potential gains? Now, it's ultimately up to the client to decide, but I think part of your role is to ensure that they have full options made available to them. Tanya says, got to think about the client's financial position, which is absolutely true. But it's not more than just the client's financial position that you need to consider. You need to cater for the client's overall circumstances. Now, some of the impediments that a client might have include things like their intellectual ability. It may be that the client is suffering from the adverse effects of age. There might be cultural factors. There might be issues to do with extraneous requirements to assist with family or friends or anything else. So you need to consider all of these things when considering giving advice to a client. Now, I mentioned guardianship, administration, and powers of attorney earlier, which was really identified correctly as this issue of the client's capacity to make decisions.
Can I ask you a question, John? And this
Yes.
is more of a, it's a personal opinion on the professional sort of side of things. Do you feel, as someone who's been in the industry as long as you have, do you feel that Australia does provide an adequate amount of help? Do you think we could be doing more to help people? And do you think there should be more knowledge for the services and advocacy for the help? Or what's your take on it?
Oh, I think that we're so much better than we were 30 years ago or 40 years ago
Yeah,
when I started. But like everything, I think there's still room to improve, but definitely moving in
yeah.
the right direction. And I think lawyers have a big part to play in this because lawyers have really broadened their horizon and the way they think
Well,
about
that's why I want to get into it, is exactly that, yeah.
it. And you can understand that I'm threading through all of this discussion the issue of ethics, because so much of this relies on ethics and your ability to understand and apply the ethical issues that might be there. Now, for example, I mean, we talked about capacity. If a client comes to you and says, "I want to sue this person," for example, but you determine that the person has no real capacity to understand the value of money and no real ability to understand the benefits and the costs associated with litigation. I mean, it's easy to say, great, I'll take your money. That'll be $100,000 to sue for this defamation claim. I'm not exaggerating on the figures. It'll be $100,000 to sue for the defamation claim. If you're successful, you might win $5,000. Do you want to proceed? If the client says, well, yes, I do, then you've really got to test them. You've got to make sure that that is an appropriate course of action. You don't want to be involved in litigation that is unrealistic or unremunerative. Defamation is always a good example of that. And you have legal obligations, ethical obligations, case management obligations, and these are now contained in part in legislation. So you need to have a good idea of looking at this from a whole perspective and being aware of what the courts expect and what legal professional bodies expect also. All good? So you need to consider legal and non-legal options that might be available for a client. You need to consider what led to the dispute perhaps and how you might attempt to resolve the dispute. You might think about self-help remedies, or there might be other specialist legal or non-legal services that might be available to assist the client as well.
Do you find ADRs, like alternative dispute resolutions, to be particularly effective?
Oh, very, very much so. Yes. So, for example, I've been undertaking mediation since the 90s. So I'm accredited, nationally accredited mediator, and it's amazing the number of times where, at the start of a mediation session, the general consensus is that this is going nowhere and it's a waste of time. But after, it might take 3 or 4 hours, but generally speaking, mediations work, and we generally have a successful outcome. Well, not just me, I'm talking generally for mediators. So ADR is very
That's really
important.
good to hear.
Yep. And if you do the LAWS11057 ADR course, then we deal with a whole lot of different range of alternative dispute resolution. So when you're acting as a lawyer for a party, you need to consider risks. Do that from the outset. You need to consider and have a very frank discussion with the clients about costs. And if you don't, then you may find yourself before the Legal Services Commission, and that's what you don't want. From that, you may also find yourself before QCAT or the Court of Appeal. So these things you don't want.
Could I ask you, John, what would be, just to give a rough idea of, say, your average case of whatever, I know that's really broad, but the difference between doing it and going through the trial process or going through an ADR, what would be the cost difference sort of thing?
Well, the ADR process can occur before the matter becomes litigious, or it may be even right at the end. So that can vary enormously, but litigation is horrendously expensive. So, for
Oh,
example,
say one from the beginning. I mean, sorry.
yeah. So from the beginning, so if you had a defamation case, you know, you might be looking at $60,000 in legal fees, or you may be looking at, for litigation, maybe more, or you may be looking at, say, $5,000 or $10,000 in legal fees to resolve the matter through ADR. So, yeah, different considerations apply.
Thanks
Good
for that.
questions. No, that's good. All right, so this evening we've been talking about ethical behaviour, and where I want you to look is the Queensland Law Society Ethics Centre. Now, can I have a quick poll? Yes or no? That's all you need to provide. Have you looked at the QLS Ethics Centre website? I won't mention names, but just if you can just give me a yes or a no. Don't be shy. Well, I'm not getting any answers, so I'm going to take that as a no. So
a whole bunch. Most people said yes in the chat. I don't know if it's
did
come
they?
through to you.
Oh,
Most
okay.
of us said yes, but I said
you did.
I said I haven't, but I'm gonna.
I've got so many. The messages are getting ahead of me. All right, good. Yes, so most people have. Please do so. Excellent resource, particularly relevant for anything to do with ethical issues. Do have a look at the rules, and some of the quotes that we see are excellent. So Stafford Shepherd's in charge of the QLS Ethics Centre and does a wonderful job with his team of experts in that regard. So it's a free resource, publicly available, absolutely worth thinking about.
Which one was it again? Sorry, just so that I can write that down.
Yep, the QLS Ethics website. And if you like, the person in charge of that is Stafford Shepherd. But all right, so but QLS Ethics website. Also, there's a video that I conducted with Judge Morzone QC, so do have a look at that. When you're looking at these ethical issues, think about it from a practical perspective, of course. What you would say or do if you're on your feet in court, or if you're in an office, you're dealing with a client, or you're dealing with a colleague. And remember, of course, that as a lawyer, you have all sorts of duties. So if you're an employed lawyer in a law firm or in a government department, for example, then you've got duties as part of your profession. You've got duties to the court. You've got duties to your client. You've got duties to your colleagues. And very importantly, and sometimes unfortunately overlooked, you still have duties to your family, and you have duties to your employer. Employer seems to come last a lot in this, but it's critically important, of course. So you've got to try to mold all of that. But from a lawyer's perspective, of that list of parties with whom you deal, what is the most important from a lawyer's perspective? We're getting some votes. Benjamin said one that I didn't say, which is really, really important, and that is yourself. Thank you for adding that. Oh, that's terrible that I left that off. That's really important. Unfortunately, from a legal perspective, it's not the most important, but it's very important. Thank you for mentioning that. Tanya and Gareth are correct. It's the court. So when you read through your ethical requirements, your overriding duty, your paramount duty, is to the court, to the administration of justice. So that means that if you have a client that wants you to do something wrong, then not only do you say, it's not good enough to say, well, I don't think you should do that, but I'll do it if you want. You must say no. Do you understand? And this is the really hard practical part of practicing. To understand the ethics, the ethical requirements, then put it into context to say, in this circumstance, where do I place the loyalties? Am I entitled to say, no, I'm not going to act? And you've got to be careful not to be too conservative in certain circumstances. Now, there was a question from Tim. Oh yeah, is arbitration or mediation binding? Not sure if that's the right word. Absolutely, both can be binding. It's possible for mediation not to be binding, but usually arbitration is binding. Arbitration is very much like the court system. Mediation is more of a conciliatory type process. It's very similar to conciliation. And mediation generally results in agreement that is binding, but in some scenarios, for example, in the dispute resolution centres, if you like the neighbourhood type mediation centres, they may say, if you come to an agreement here, it's not binding. But generally, that which is agreed upon at a mediation is legally binding. I hope that answers your question. Some questions about justices. Yeah, no, the minority of, by far a minority of lawyers, barristers go on to be judges. More ethical for a lawyer to drive a Camry than a Ferrari. There's no prohibition on driving a Ferrari if you like. So there's no problem with that. All right, so last week I think I invited you to consider specific rules in the Australian Solicitors Conduct Rules and the Barristers Rules. So I'm going to leave it off tonight on the basis that you consider that, and I want you to have a clear understanding of your fundamental duties. I want you to understand to whom you have duties. Think about what the priorities are. Think about yourself in that mix, and thank you so much again, Benjamin. I missed that, but you're right. And think about your obligations and interactions with clients and colleagues, and we'll pick up from there next week. Okay, all the very best. Thank you for your patience. We'll give you some guidance in relation to the take-home exam, hopefully this week. All the best.
One
Yes,
last
Lachlan?
question, actually.
Yes.
Sorry. Results on assessment 2.
Now they finished last Thursday, didn't they?
I know it's a bit soon to ask.
No, it's not. I've got to be honest, I'm snowed at the moment, so my turnaround is a little slower than I would normally like, but hopefully sometime next week.
Cool.
So
I eagerly anticipate that.
All right, very good. And all right, well, we'll see you all next week. All the best. Bye then.